Welcome everyone again to the University of New Mexico Law and Mental Health Didactic Series. This is a series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. I'm Dr. Anthony Perillo. I'm the Forensic Psychology Training Director here in the Department of Psychiatry and Behavioral Sciences. For the talk today, if you have any questions you'd like to throw to our presenter, ask the questions in the Q&A box anytime you feel comfortable. That should be at the bottom of your Zoom screen there. We will reserve those questions until the end. We try to get to as many as possible. Just forgive us if we can't get to yours. For those of you that want continuing education credits, you do have to stay for the full hour, but you do not have to stay longer than that. If you're pursuing continuing medical education credits, there will be a sign-in sheet that'll be entered into the chat box pretty shortly here. The APA continuing education credits are posted about the last 5 minutes or so of the talk in the chat. Make sure you open that before you leave, and you'll have to save your certificate. We don't keep records of those certificates. We can't give you the link after the fact, so make sure you open that link before you leave this and complete that survey because we don't keep copies. As a heads up for next week's talk, next week we'll have Drs. Antoinette Kavanaugh, Dr. Victoria Petruska, and Dr. Danielle Rinzak discussing incorporating racial trauma and vicarious and direct police contacts in Miranda evaluations. But this week, I'm very excited to share with you. I'd like to introduce you to our speaker who will be helping us explore multiple relationships in forensic psychology, Dr. Michelle Guyton. So Michelle Guyton owns the Northwest Forensic Institute, providing evaluations and education in forensic psychology since 2008. She's a licensed psychologist and certified forensic evaluator in Oregon, and is one of 5 board-certified forensic psychologists in the state and the first woman to hold this status. Since 2005, she's been in Oregon and worked in the School of Graduate Psychology at Pacific University for 10 years. There, she functioned as an assistant, then tenured associate professor, director of the forensic track, and other administrative capacities. She's published in the areas of violence risk assessment, inmates' adjustments to prison, and forensic assessment instruments. Dr. Guyton also worked at the Oregon Department of Corrections, where she provided treatment and assessment services to male and female inmates with serious mental illness. She is the director of the Oregon Forensic Evaluator Training Program since its inception in 2012, a state contracted program providing initial and recertification trainings for evaluators conducting competency and criminal responsibility evaluations. She's the training director of the Northwest Forensic Institute's postdoctoral fellowship and practicum student programs. She also provides trainings to forensic mental health professionals, lawyers, judges, and other justice-related agencies, as well as providing consultations to these groups and other government entities. She's done forensic evaluations on fitness to proceed, criminal responsibility, sentencing, competency, violence, psychosexual risk assessment, personal injury, fitness for duty, testamentary capacity, the list goes on. Michelle, on behalf of the University of New Mexico, I want to thank you. We're very excited to have you join our series and share your expertise and your thoughts with us. I'm now going to throw it to you.
Well, thank you. And thank you for that lovely introduction. And I do just want to take a moment to say thank you to the University of New Mexico for inviting me back. It's lovely to be here with all of you. And well, wherever you are from my home office in Portland, Oregon. Thank you to Anthony and to Alex for helping me get this set up, as well as Jeff. It's an honor. So these first few slides we'll just wing through pretty quickly. You just heard about me, so you don't need any more of that. Anthony kind of went through some of this. I have no financial relationships with anybody related to New Mexico, and these are obviously my views that we'll be talking about today. Just for reference, in case you're like, she's not very polished at this talk, it's because it's the first time I'm giving it. I wanted to do something kind of new, kind of an offshoot of an area that I do talk about in larger ethics trainings, but I think is pretty nuanced and is something that is deserving of a little more attention. And so we're going to spend our hour really talking about multiple relationships in the forensic evaluation context. And so we'll review some ethics information around what a multiple relationship is and sort of the ethical frameworks around that that guide our behavior in these sorts of contexts. We'll talk about how we want to apply ethical decision making, and I'll suggest to you a couple of extra steps that I think are useful to highlight when you are thinking about your ethical decision making in these contexts. And then, of course, because it's an ethics presentation, we have to apply it to a vignette or two. So I have two. Hopefully, we'll have time to do both of those today and just kind of help us think through. And what I'll say is that this presentation was sparked by a number of things. One is just the conversations that we have when doing ethics trainings around forensic issues and the issues of managing professional relationships successfully, and with an eye towards reducing harm and conflicts of interest and things like that, right? So there's factor number one. I think factor number two that often happens is for us as in the agency that I work with, and I have a number of wonderful colleagues on staff, and we have our postdocs, and typically when our postdocs are interviewing and then our new folks come in, they may be unfamiliar with the private practice environment, which is what we are. And some of the sort of day-to-day nuances that may not be present in an institutional setting, but are kind of part and parcel of doing the work the way that we do it. And just in terms of managing referrals and sort of how those referrals might bump up against each other or overlap. And then finally, a shout out to my colleagues on the ABAP, forensic ABAP listserv. There was a discussion a number of months ago around this very issue that sparked a great conversation and dialogue among really smart people who really didn't very much agree with one another. Well, I mean, there was some agreement, right? But there were really different viewpoints, and so I was really curious about, well, why is it? Why do we come to these different viewpoints on the same topic when everybody's looking at the same ethics code and has a good head on their shoulders? So we're going to try to try to unravel that just a little bit and we'll see how we do today with that. Just a brief note about culture. Culture can clearly impact our decision making as individuals, right? Because we are all individuals of a particular or set of particular cultures that influences our decision makings, our values, our priorities, things like that. And that can influence the perceived permissibility of multiple relationships. Things like your setting, like where you live, right? And these kinds of issues can also impact the nature of how we think about relationships and their permissibility. I will also suggest to you, and maybe you've had this experience in your own work, is that the use of language interpreters can also influence and provide an opportunity for all kinds of multiple relationships to arise. Sometimes a multiple relationship for someone adjacent to you in the case, right? Somebody adjacent to you, like an interpreter whom you're working with, might have a multiple relationship. And so maybe it's not your multiple relationship, but now you're linked to them and they may have some influence on your work, right? So we have to kind of think about this in a broader sense and figure out what we need to do to both safeguard the people that we work with, safeguard ourselves in terms of liability, but also safeguard our opinions so that they are acceptable to the courts and other bodies who receive them. Okay, so all of this talk about multiple relationships, well, let's talk about what that actually is. So if we look at the ethics code for psychologists, right, which I know you're all familiar with, the human relations section guides us. That's section 3, and we'll kind of break that down. But it really guides us to practice that general principle of beneficence and non-maleficence, right? That we are here to do good and to not harm people through our work, right? And I think as forensic clinicians, we have a special recognition of the nuances of that, right? Because we do provide evaluations that may result in negative consequences for someone. So if you do a risk assessment and you find that this person is very risky, and you say that, and this person gets a longer sentence or doesn't get out of the hospital, right? That could be perceived as a negative, for that individual, but perhaps a positive for society because you are, functioning to protect society. So I think it's important to think about that, when we are making distinctions and we are practicing these things, it is in a very nuanced context. So we avoid discrimination, but it's of course unfair discrimination, right? So we do discriminate. We discriminate on the basis of many features, but we have to do so fairly and in an evidence-based way that doesn't suggest that we are discriminating against a person or a group of people based on their specific characteristics, right? And that we are aware of bias and the ways that that can influence our decision making in a number of ways. We also, of course, want to avoid harassment, sexual harassment, but other forms of harassment as well. So we're, trying not to annoy and bother people, which is why I think, when we develop our relationship with somebody in order to do the evaluation, we also recognize that if the person doesn't want to talk to us anymore, maybe we're going to stop, asking them questions. In our state, we have a law that says we don't necessarily have to stop questioning them, but I think from an ethical perspective, I'm not going to annoy and harass this individual if they don't want to talk to me. We additionally, beneficence and non-maleficence also talks to us about avoiding harm and avoiding exploitative relationships, right? So harm, again, is nuanced, but if there are foreseeable harms and we can take steps to move away from those, then that is something that we should be doing. And part of that is the foreseeability of it, right? And so for those of us who kind of are in the forensic trenches doing this day in and day out, you can often see the harm coming, right? And in a lot of cases, right? You're like, oh, that's going to be an issue if I don't take care of it now or I don't sidestep it. I think for people who are newer to forensic work, whether that's because you are a student or you practice in a more general way and don't do a lot of forensic work, some of those harms may be harder for you to see ahead of time until you're kind of in the mix of it. And then you're like, oh no, now I'm in trouble. What do I do? Right. So part of it is figuring out if there's harm that we can avoid before even getting there, right? Whether we decide not to take the case or we make a referral or we take steps to do things in a particular way to minimize that risk to people that we work with, that's useful. We also don't want to be involved in relationships where we're exploiting people, right? And you might think in general, I'm not generally exploiting people, but you can think about, money is a powerful, incentive, and so to make sure that we don't get blindsided by how much money we might make in a particular case or the notoriety of a particular case, maybe it's not a good idea for you to be involved in that because you have some other connection to somebody involved. It might be perceived as a multiple relationship. These are all kinds of things that we want to be thinking about. Additionally, the human relations section 3 of the ethics code, is also informed by general principles B and C. So fidelity, responsibility, and integrity, right? So we want to avoid conflicts of interest as much as possible. And importantly, the appearance of conflicts of interest, right? So sometimes you may not be engaging in anything unethical, but if it looks bad, right? You're pretty sure an attorney or other person can make it seem like it's bad, especially to a judge or a juror who may not be familiar with psychological ethics, right? So we always have to be aware of what we're doing and then how it looks to other people and how we're able to explain that behavior to other people. So a conflict of interest is when a psychologist takes on a role where it could impair their objectivity, competence, or effectiveness, or it could expose one or more persons or an organization to harm or some form of exploitation, right? So you want to avoid those kinds of situations. So maybe, you saw a person for, maybe you have let's say you work for the state hospital and you have a private practice and you saw somebody at the state hospital and then this person is referred to you in your private practice, disagreeing with yourself or maybe some of the confidentiality rules that exist between those two organizations, the state hospital and the private practice setting, might create a conflict of interest where you may know things that you shouldn't know in the second evaluation, right? So we might want to avoid that. And then obviously we're here to talk about our multiple relationships. So let's kind of break that down just a little bit further. So this is from the ethics code, and I think this is important, and you don't glaze over just yet with me, because this is something that sometimes I think people forget, is this actual definition and what the ethics code says about a multiple relationship. So a multiple relationship occurs when a psychologist is in a professional role with somebody, entitled them person A. And then one of three other situations is happening. Okay. So they're in a professional role with person A, and at the same time, they're in a different professional role as person A. Okay. And we'll look at some examples of these in a bit. The second opportunity is if you're in a professional role with somebody and then you are at the same time in some other kind of role, whether that's professional or personal, who's closely associated with person A. So, right, so maybe person A's spouse or person A's co-defendant or co-litigant. And so, there's somebody who's related to this person in some kind of way that may have some bearing upon the work that you're doing in your professional role with person A. And then lastly, the professional role with person A, and then the psychologist agrees to or promises to enter into a relationship with that person in the future, or somebody associated with that person in the future. Right, and again, it doesn't say professional or personal, but sort of talking about, well, I'm doing this assessment with you now, and I'll go ahead and do treatment with you in the future. That might impact the professional role that we have to do the assessment, or if they know that we're going to be working with somebody that they know, the family member or coworker, co-litigant in some kind of way, right? So this idea that there's relationship between people and these relationships are sufficient enough, closely associated enough that it has the potential for perhaps impacting work, right? And this question of whether a multiple relationship is inherently unethical is, I think, a good one, because it is something that has evolved over time. And if you read about people who have been writing about multiple relationships over time, there kind of is this initial knee-jerk reaction that people have had of like, oh no, multiple relationships should be avoided at all costs, right? That there's always the potential for something unethical to happen or some kind of harm or risk to somebody, so they just cut it off. And I don't think that's a wrong way. I think that's a particular stance, but I think it's a lot more broader and nuanced than that. And as Zur talked about I think in the title of his edited book from 2016 on multiple relationships, is that these are often unavoidable, they are often common, and they are often mandatory. So you may work in settings where this is kind of a required part and parcel of how you do your work. You may work or live in places where you can't avoid these kinds of situations. I live in Portland, which is a pretty good sized town, and I have run into some multiple relationships quite by accident, just by being a person who also has a life outside of work, and coming into contact with people in that kind of way. So I think it's important for us to be mindful of knowing what a multiple relationship is, and then how we should think about it or what we should do. And I'll tell you that no, they're not inherently unethical. This ethics code doesn't say that, thou shalt avoid multiple relationships at all times. And what it says is that a psychologist refrains from entering into one if it could be reasonably expected to impair the psychologist's objectivity, competence, effectiveness, or otherwise risk some sort of exploitation or harm of the person. Okay, so I think this is really the hard part. The first part of like identifying the multiple relationship is kind of step one. Is this a multiple relationship? And most of the time, but not all the time, that's pretty easy to figure out. The second piece of well, let me think through the possibilities involved in this particular situation to determine whether it could risk harm or impair my capacity to do a good job in this case, or impair the capacity of the report that I write to be influential with the court. Because if it's thrown out by the judge because they think I have some sort of conflict of interest, right, then I've done nobody any good and I've wasted a lot of resources that are usually quite precious. So these are the things that we want to kind of think about from the ethics code perspective. The specialty guidelines for forensic psychology, right, which is the sort of supplement to the ethics code that specializes on how people in forensic work do things, gives the same definition, but adds this one extra piece. It has these three sort of bullet points, 1, 3, and 4 are the same as the AP ethics code, but it also adds in is involved in a personal, fiscal, or other relationship with an adverse party, right? Okay, so that's important. So kind of gives this additional way to sort of think about there's some other party to this situation, whether that's a criminal forensic evaluation or a civil forensic evaluation or administrative, some kind of thing. And do you have some sort of relationship with this other party, right? So we wouldn't agree to the prosecutor on a criminal case, we'll do an evaluation for you, and then we're hired by the defense to do the same evaluation on the same person, right? Like that would just red flags all over that, right? Because it probably would impair objectivity, confidence, and effectiveness, and there would be confidentiality issues and all sorts of various kinds of things like that. And the specialty guidelines talk about our need to strive to recognize the potential for conflicts of interest and threats to objectivity. And I'm just going to underline that for a second, the potential for, right? So again, the specialty guidelines are noting importantly that that multiple relationships are not inherently conflicts of interest or not inherently threatening to your objectivity, but that potential exists. And it is our job to recognize that, which the only way we can do that is like to sit and think through that and consult with colleagues. And, we'll go through that process a little bit in a moment in terms of ethical decision making. But it is our job, often before we ever say okay to a case, that if we can reasonably foresee some sort of conflict or the potential for conflict or multiple relationship, that we think through that before we agree to do that. Now, sometimes you work in places where you do not have the liberty of saying no to things, but you may be able to ask for, swapping a case with a colleague or something like that, or consult with your supervisor if you feel like you're really in a bind about a particular thing. So, and noting that this is inherent in multiple relationships, that this potential for problems, but not that it exists in all situations, right? So you'll hear me sort of advocating through this, taking I'm not a hard nose, like do all the things or, never do anything involving a multiple relationship. I really kind of want to sit in the middle and say, it really depends on what you're doing, what the circumstances of this case are, how do they relate to this other secondary role that you may have or you already have, and try to think through these issues to make an informed opinion about how you're going to proceed with this case. So I hope that I don't get to see any like faces nodding or anything. So I hope that's all making sense. And we'll work to apply it in a little bit. So you probably have your own examples of different kinds of multiple relationships that you've encountered, or when you have consulted with colleagues about their work, they may have talked to you. And so I've just got a couple here that I want to throw out for you. And then we're going to take two of these and talk about them a little bit later on, and I'm applying our ethical decision-making model at that time. All right, so psychologist A, you can see I put a lot of effort into naming these psychologists. So psychologist A is hired by a defense attorney to evaluate a defendant for competency. The psychologist was just previously hired by the DA in the same county to evaluate a defendant for insanity in a separate case, but it is the same district attorney in both cases, right? So in this case, psychologist A is doing defense work and they're the same attorney is on the case, but they've also been hired by that attorney in a separate case on a separate referral question. And so now the psychologist is kind of wondering, like, is this okay? All right, psychologist B is an individual therapist and team lead for a patient committed to a hospital as insane. Psychologist B also provides the risk assessment for that patient to determine if they meet criteria for remaining in the hospital, right? So if we look at this, we can see that there's a sort of a dual role between a therapeutic relationship with the patient as well as an evaluative relationship with the patient. And those two things might interact and overlap, but the evaluative relationship, assuming that the patient would like to get out of the hospital, patient might be vested in a particular outcome, which may or may not be the decision that is supported by psychologist B's findings, right? So we see some potential for the tension between therapeutic and evaluative roles for psychologist B. All right, psychologist C conducts a defense retained competency evaluation on one of 3 co-defendants. All those cases resolve, and years later, psychologist C is then requested to evaluate a different co-defendant. So not the co-defendant they originally evaluated, but another one within that group of 3. And they are requested to evaluate for post-conviction relief, which is like an appeals process, on whether the insanity defense should have been explored for that particular defendant. Okay, so now we have a situation where there's a time lag between the roles, right? So the role with, the first examinee happened, and then years later, a second examinee, but that was connected, right, in terms of being co-defendants with the first evaluee is requested for an evaluation. And so the psychologist is kind of wondering, like, what is this okay? And for those of you who were on the listserv discussion around this is similar to the case that was discussed on the listserv that generated a lot of good dialogue. And then lastly, psychologist D is working in a pretrial detention facility that conducts competency evaluations, and they overhear one of their examinees in the hall discussing plans for an escape attempts. So this is probably a pretty common experience, maybe hopefully not discussing plans for an escape attempt, but the idea of having multiple roles as a psychologist in an institutional or correctional or secure care setting, where the psychologist is not only in an evaluative role with the examinee, but they are also in a role where they are committed to institutional security and safety, right? And how do you manage those roles together? Oh, and then lastly, psychologist E conducts a forensic evaluation with the use of a language interpreter. At the conclusion of the evaluation, the interpreter tells you they used to date the examinee's mother, and they believe the examinee was lying about their social history. This is one of those moments where you hope, like, this doesn't happen to you, right? Suddenly you learn about some information, and this is a situation where you may not have a conflict of interest or a multiple relationship with the examinee and somebody else, but it sounds like this interpreter may have had a multiple relationship, right, in terms of a personal role and a professional role with the examinee. And because that person is your interpreter on this case, it's now your problem, right, in terms of what to do at this point. So I sort of like that, like this example, because it shows the capacity for, like, you might have planned for things, and then sometimes ethical problems just jump in your lap despite your good planning. So you have to be prepared to think about these and deal with them. All right, and then this last one, psychologist F conducts a defense retained competency evaluation. The following year, psychologist F is asked by a new defense attorney to evaluate the same defendant, right? The defendant now has some new charges, and you ask the original defense attorney, hey, can I use the evaluation that I wrote on your client in my new evaluation? And they say no, right? So now you're like, what can I, there's information I already know. What do I do about that in approaching this new evaluation? Right. So these are all examples that have come up kind of more or less in the context of discussions that I've had with people, or in the work that I've done, or people at my office have done. And I think they're just kind of useful to sort of show that these multiple relationships can spring up in a number of different ways, but they're all sort of different at the same time, and how we approach them each time might also be different. Okay, so before we jump into ethical decision making, these 4 A's from Bush, Allen, and Molinari on their work in ethical decision making and geropsychology talks about thinking about these 4 A's, and that these 4 A's can do a lot to help us, right? If we can anticipate the types of things that might be happening, we can then prepare for them, right? So if we know the type of work that we do, we know these are the most common multiple relationships that occur, and we can prepare for them, then we can maybe head off some things at the pass. We also strive to avoid ethical misconduct. So anytime that we have the opportunity to take an active step to sidestep or avoid problematic situations, the better. We want to address it when it happens. No hiding your head under, in your turtleneck, and avoiding things. We need to address things when they happen so that they do not snowball and become a larger problem sometime later on, right? And then lastly, we want to make our commitment to the ethics code known, not just the enforceable standards, but also the general principles, that we don't want to just do the baseline floor of ethical behavior, right? That, okay, great, we're not going to get a board complaint, or if we do, it's not going to be successful. Well, that's lovely. But I would also suggest that we hold ourselves up to a higher standard and aspire to work at a higher level of ethical behavior in our professional work. Okay, so these next 2 slides are kind of the ethical decision making model that I have put together from a variety of different sources, along with some of my own thoughts about how to approach things. And always the first step is to identify the problem, right? What is the problem that we're dealing with? And some of the important things to think about is that this might not actually be an ethical issue. Sometimes it's a legal issue. Sometimes it's an organizational issue that's happening because it is something unique to your environment, and your organizational rules are such that you need to do something, and that maybe is in conflict with your own values. Or it can be kind of intersectional, where you can have what often happens is like an organizational rule. And if we think about our escape attempt guy, there may be organizational rules about reporting unsafe behaviors, but then ethical mandates around confidentiality and things like that might seem like they're in conflict, or they might actually be in conflict. And so we have to recognize all of those things. You also have to, when an ethical scenario presents itself, it tends to produce an anxiety response of varying degrees in the person who's receiving it. And so in that moment, you may not be perceiving things very clearly. So you want to sort of separate what you know versus what you believe, or what you assume to be true, or what you fear is going on. And really try to set out what it is that you know, and what it is that you don't yet know and need to find out, right? And then importantly, you also want to think about who you are as a person, and your own values and morals and beliefs and biases. Now, we were just having a conversation in my office last week about during a training activity about how Oregon is a permissive reporting state. We're not a mandatory reporting state for different types of abuse when it's learned in the course of a confidential communication. And so people were talking about, well, it's my value and belief that these should always be reported, right? And so it's important to consider who you are also, and how that influences what you're thinking about. And in forensic work, we have often been encouraged to think about who is the client, because that has important ramifications for a variety of things. But I would say that's insufficient. We need to think about, if Mary Alice Fisher wrote about this in 2009, about identifying all parties to whom you owe a duty. So, just because maybe an attorney retains me in a particular case, that doesn't mean I don't have ethical duties in relationship to the examinee, right? And I also think about that more broadly. I believe I have ethical duties related to the judge in the case, or to the public, if this is an issue around public safety. And so think about who those parties are and what duty you owe and in what extent, right? And maybe there's like some rank ordering of the people that you owe the most duty to versus something of a more generalized duty. All right, so we've done that. And notice like we've sorted a lot of things out before we start moving to other sources of information to help us out, right? If we jump to immediate consultation, for example, without really thinking about what the problem is first, we might kind of waste that consultation and use that consultation to actually figure out what the problem is. So if we do a little homework before we move to do some of these other things, that will help us, right? And so we need to understand that maybe this is a legal issue. So I need to consult the laws or the administrative rules, or I need to look at my organizational code of conduct to understand what this is. And then maybe I also want to consult with my colleagues, professional organizations, right? Whether that's, your state psychological association or APA or ABAP or various other places that have these decision-making kind of support services for people who are struggling. If you can also always call your insurance provider. They often retain consultants who can provide some support around these issues. It's one of the reasons I love working in a private practice with really great people is that they're really helpful in providing some consultation and thinking through these issues. And if you don't have people that you work with because you're in an individual practice, make friends, but make friends with people that that you find value in how they think about things, and make some documentations of that, right? Of like I consulted with so and so around this issue because just from a risk management perspective, that's useful. Additionally, you want to think about what are the ethical principles that are most important to you in this situation. As some writers have kind of written about, there's sort of a pluralism of different types of values, and sometimes we may prioritize certain types of values or ethical principles over others, right? So not harming others might be prioritized over confidentiality, which is why somebody in a permissive state like Oregon might choose to break confidentiality in order to protect, a vulnerable person. And then these are two things that I would suggest are important and useful in understanding people's different approaches to different types of situations is how do I assess the risk of potential harm or conflict of interest or compromised competency or effectiveness in this particular case, right? Is the risk for that high because of X, Y, and Z? Or based on my experiences, does this like seem unlikely that bad things would happen? And I would say to you that most cases that you take where there is no multiple relationship, and you're like, it's unlikely, I don't foresee anything bad happening, but sometimes weird ethical situations end up in your lap despite your best efforts, right? So we're never like at a 0% risk for ethical conflicts or murky situations arising, right? So we really want to make sure that we are thinking about that assessment of risk. And I think that assessment of risk is pretty individualistic based on who you are, what your experiences are. And this last piece is your tolerance for risk, right? So how tolerant am I to the potential risks that are in this situation? And I think this is another area where people vary, where people can say, I think this is a manageable risk because if something does arise, I can do X, Y, or Z. Whereas another person might say, you know what, that's too much risk. I don't like doing work where there's like, any increased potential for shenanigans. And so I'm just going to say, no, thank you to that particular situation. And I think both are fine, but you have to understand the risk before you understand your own tolerance to it, right? And so part of this is just doing this sort of self-appraisal situation in terms of what is the risk and what is my tolerance for the risk in this situation. And then you want to think about like, well, what can I do, right? This is a generating of potential ways of thinking about things, enumerating the consequences of each of those actions, and then thinking about the fairness of this, the publicity. I always like to think about, if I had to explain this behavior on the stand and I had a really good cross-examining attorney asking me these questions, like how would I do, right? And if this is like If it would be really challenging to explain this in a way that comes across as genuine and straightforward and in the best interest of all people, then that should tell you something. And then lastly, would you recommend this course of action to someone else or say, oh, you shouldn't do this, but it's fine for me to do it, I think is also a red flag. And then you implement and follow up to see how it worked, right? Maybe you learned something out of this. And you're like, well, I thought this was an okay situation. Turns out it wasn't. Not going to do that again. Or other types of nuanced things that you might learn. When we're determining if a situation is a multiple relationship, we want to define the original and any subsequent roles with all the relevant parties. Determine the time sequence for that. Are they presently co-occurring? Or is it something that's in the future or in the past? And are you making plans for future roles while you're in a current role? Secondly, you want to think about what the ethical principles are to you in this situation. We've discussed that already. This value pluralism that is important to think about is there are probably competing ethical standards at play here, and you may not find one that is considered superior or overriding in this particular situation, right? You want to honor both of these, but they are coming into conflict, and to think about, well, this is also why people come up with different ideas about whether we should, move forward or refer out or other kinds of things, is because we may value these ethical principles differently. It doesn't mean we're not acknowledging them, but we may just have different ways of looking at what's happening in those interactions between those ethical principles. Obviously, you want to understand if you could cause harm. And usually we're not talking about physical harm, right? But with forensic evaluations, right, these are often costly evaluations. They take time to do. It pauses a case in order for the psychologist to complete the work. And are we harming it by sort of taking on this, if our report gets thrown out or pieces of it get thrown out, or we look bad, or we look like a non-ethical provider, that may have harm to the side that has retained us, or to the examinee or other parties. And so it should be important. I also want you to think conversely about, is there harm to the examinee or other parties by not taking on that secondary role? Could we actually be beneficial in some kind of way by taking on the secondary role? That may not always exist in all cases, but it's something to think about. And then obviously, is it possible for your objectivity, competence, or fairness to be compromised if you take on this secondary role? Second, you also want to think about what is the level of risk posed to all parties. So if you are compromised in some kind of way, what is the potential harm? And how likely is it that your work could be compromised or harmful? And again, this is based on your own experiences, the experiences of others, your own common sense, the way that cases work for you or your agency or in your jurisdiction, right? There's a lot of, I think, nuances and case-specific information that could turn something one way for one psychologist and turn it another way for another psychologist, and both of those would be okay. Secondly, you also want to determine what is your risk tolerance. So has this happened to you before? What are the potential harms and their likelihood for that? And understanding that what is your level of comfort in proceeding? Are you going to be so worried and anxious about something bad happening that you can't, give your full attention to that? Like, that sounds like it may be too much risk, and you need to, step away from this secondary role. And also understanding that moral acquaintances can differ, right? So this idea that we have different values and we may value them differently, and we're still living in the same moral world, but we value things differently, and that's okay. And so understanding that, respected colleagues can differ on things. So let's try applying this to a particular case, shall we? Let's go back to psychologist A, who's hired by the defense attorney to evaluate a defendant in one case, and hired by the DA in a different case, unrelated case, to do an insanity evaluation, but you have the same DA in both cases. So is this a multiple relationship? So things that we might want to consider given this particular context is, does who is retaining the psychologist matter? What is the time frame of the different roles, right? Is like one going to finish before the other one starts, right? Sometimes, you start a case and it goes forever. What's the level of overlap? How similar or different are the roles in the two different evaluations? And what can the psychologist reasonably be expected to know at the time, right? So, a lot of times we might say, well, they should have known this. Well, maybe they didn't. Maybe they should ask some questions to gather that information, but we don't have the benefit of hindsight in determining whether this was okay or not. So we have to kind of make a sort of prospective decision. So in terms of the language of the ethics code, is it a multiple relationship? Yeah. Psychologist has a professional role with the DA in a competency case, and a different, albeit reduced, but simultaneous role with the DA in the insanity case, right? And I think this is something that's probably going to happen to a lot of different people when they are doing these types of evaluation. If they have private practice, you work for a variety of different referral sources, you're going to come into contact of working for people on both sides of the case, and sometimes you're going to have different DAs or defense attorneys that overlap. So I think you also then want to think about, well, all right, so it's a multiple relationship for psychologist A. Does it impair their objectivity, competence, or fairness? Does it create a conflict of interest, or does it threaten the objectivity of the psychologist, or does it appear to threaten the objectivity of the competent, or the objectivity of the psychologist, right? So these are all things that we want to think about. As we think about that, we're going to appraise risk. We're going to think about, well, what's the risk to people in doing this? What's my tolerance for holding on to this risk while doing these kinds of evaluations, right? And so I'm going to show you, well, this is how I think about it, but you may find that you see it somewhat differently. Okay, so using my values, risk appraisal, and risk tolerance, I don't think that this is too difficult of a situation for psychologist A. And again, there could be some case-specific information that would change my mind about that. But since I did the vignette and I didn't put very much in, we're going to go with this. So I don't really think this impairs, it's two separate cases, right? It's defendant A over here and defendant B over here. They're not, their cases are not linked in any kind of way. And what psychologist A does in one case has really no bearing on the secondary case, or vice versa. Now, in the first case that's defense retained, that DA may never see that evaluation, right? If you come back and say, well, defendant was malingering or is antisocial as the day is long, they may choose not to share that, and the DA would never know that evaluation existed. Now, it's possible that you do that evaluation for the defense attorney in the first case. They turn it over, and then the DA is like, I don't like this evaluation, or I think this is a poorly done evaluation. And that could change their appraisal of you, but I don't think it's going to impair your objectivity in the case of the insanity case that is hired by that DA, right? Like, that's just kind of the cost of doing business. And if you don't do good work, or they don't agree with you, they might not like you as much. But again, that's part of being a forensic clinician, and sort of moving through that. So if you have thoughts about this, you can feel free to put them into the Q&A, and if people have questions about it, we can maybe discuss it at the end a little bit. All right, so let's apply it to psychologist C. And so, oops, my mouse is having trouble. So psychologist C, if you'll remember, conducts a defense retained competency evaluation on one of three co-defendants, right? So then some time passes, all of those cases resolved, psychologist C is all done with case number one, and then they are approached and requested to evaluate a different co-defendant for post-conviction relief on whether the insanity defense should have been explored, right? So the second defendant is saying, hey, this should have happened, is asking for an appeal. And the attorney for that person is asking psychologist C. And this may happen to you, or it may have already happened to you, or it may happen to you in the future, where people are like, well, you have some case knowledge, right? Like you understand what happened in this case, or maybe there were some, unique or interesting things that happened in the case. And they think, well, you did it already. You did a great job on that one. I'd like you to do it this time. Right. But here, this is a little bit different, right? This is a little bit different. So now it's not the same DA and it's not the same examinee, but these people were linked in terms of their participation alleged or actual in the same crime. So the first thing we want to do is decide, is this a multiple relationship or not, right? Things that we want to consider is, does the retaining party matter for either of the evaluations, right? So is it the same attorney that's asking for both? Is it different attorneys? What would happen if it was court? One of them was court ordered, right? Or other types of ways in which retaining party might differ. Does the relationship between the retaining parties matter for either of the evaluations, right? So if these are two defense attorneys, okay, that's interesting. Does it matter? Does it make a difference if one is a defense attorney and one is a court or other sort of court-ordered matter, right? And does that play a role or difference in your thinking? How does the time frame of these evaluations impact involvement, right? One of them is done. The other is beginning. Or has not yet begun, right? So there really is an overlap there. And then how similar or different are the roles, right? So we're in an evaluative capacity in both of these situations, but you have different referral questions, but closely linked referral questions, but certainly different referral questions. Okay, so let's think, is this a multiple relationship? I would argue, no, it is not. It is not a multiple relationship because the person is not holding simultaneous professional roles or personal roles with two people, right? There's a time lag here. There's years that have gone on between evaluation number one and potential evaluation number two, right? And the psychologist, as long as the psychologist did not promise, right, I will do the post-conviction relief evaluation for you in a couple of years if you're convicted, right, to this other co-defendant, which unlikely to happen. I would say, no, this is not a multiple relationship as it is defined in our ethics code. However, does that mean that we can just be like, well, totally fine. We can do it, no big deal. And I would say no to that as well. It does matter because we need to consider the spirit of the ethics code beyond the letter of the law or the code, right? So if the ethics code is like, this is not a multiple relationship, great. However, does it present the capacity for conflict of interest or the appearance of conflict of interest, right? Which is a different ethical standard. Does it suggest the potential to think about, does this risk exploitation or harm of, examining number one or examining number two, right? I don't know the answer to that, but we need to consider that in thinking about it. So again, we need to be nuanced of like, well, no, it's not a multiple relationship, but they are roles that are closely intertwined and have the capacity potentially to create some difficulties for us or for the people that we work with. So we need to be thinking about those. All right, so let's apply it. Is this new role likely to impair psychologist sees objectivity, competence, or fairness, right? Will they be less objective because they knew something about the case? I would also suggest to you thinking about, well, the competency versus insanity, kind of retrospective insanity, are two different referral questions. I think the calculus might change if they were both insanity cases, where you're talking to both examinees about what happened at the time of the conduct, right? I think that plays a difference versus somebody's competency, where you may not have talked to them about their function or behaviors at the time, or talked about their co-defendants, but maybe you did, right? So those are things to be thinking about. And what would you do with that information if it conflicted with what you got in the second evaluation? And I think this all kind of goes under threats to objectivity, or the conflict of interest, or the appearance of conflict of interest. So before you answer, again, we're going to think about what are our most prioritized ethical values that we're thinking about and that guide us in our work. We're going to perform a risk analysis of like, well, has this happened to us before? What are the likely things that could happen? How could I mitigate that risk? And then we're going to think about, is that risk worth it? Is it manageable for me or somebody else? Is this too much? Is it just the harm or risk that is available to somebody too much, right? And I'm going to pass on it and suggest somebody else that does it. So using my own values, risk appraisal and risk tolerance, and depending upon the nature of the cases, this could be a reasonable thing to pursue. It could also be reasonable to be like, no, thank you. But remember, we're moral acquaintances. So if you differ from my thoughts, or I think that's okay, because smart people can have different ideas about things that are murky. And it really depends, right? If the first examinee spoke extensively about in their competency evaluation about the alleged at that time crime, what they did, how other co-defendants participated, et cetera, then it might influence your thinking about, well, how can I unknow that information in the second evaluation? Versus, if that really wasn't covered in the first evaluation, and you don't have any knowledge or understanding of that, maybe that's something that can be set aside and you could proceed. But again, competency versus insanity is, I think, an important distinction. And if you don't have any known problems with confidentiality, the potential to harm the examinee or related parties, in terms of swayed judgment, what I'm talking about there is your capacity for any sort of affiliation or allegiance or prior knowledge influencing that second opinion, right? Whether defendant A was competent or not probably has little to do with whether defendant C had a good chance at an insanity defense or not. I mean, there may be situations where that's different, right? But in general, those two things could be reasonably independent, which might mean that you could feel comfortable moving forward after a very careful analysis of that. But you could also suggest, either due to the circumstances of the case, your own level for tolerance of risk and shenanigans, that you're like, you know what, this is too much. I think somebody else who's clean, not to suggest that you're dirty if you do the same case, but somebody who's fresh and has had no experience with this case whatsoever would be a better person to do this case. All right, so that is the content piece of it, and I'm excited to see if there are thoughts or questions from the audience about this topic or about these vignettes.
Well, thank you so much, Michelle, both for providing a general framework for a lot of us to be how we can explore these issues, but then also letting us practice by bringing up a lot of these issues. In looking at the questions so far, I think people are returning the favor, because a lot of the questions are different hypotheticals in terms of different considerations. So I might throw a few of these out at you if you're okay with that.
I think we can do that. Yeah.
Yeah. So one scenario that was brought up was, so hypothetically, if I were providing testimony for a civil case against the VA hospital, but I am a veteran who gets my healthcare benefits from the VA, does my beneficiary status constitute me having a relationship with the opposing party?
Interesting. Yeah. I think this is the difficulty of throwing this wide open, right? Because there can be so many unique sort of circumstances. And I would think that a person, right, who is someone who has some connection with the VA might have some specialized knowledge as a veteran and as a person who's received services through that entity. They might have some specialized knowledge or understanding that someone like me who isn't a veteran or does not receive services there might not have, right? So that might be a reason that they were sought. So I think in some ways that dual role might be beneficial in some ways. And I think it's a personal role and a professional role at the same time that the psychologist is having. And so how to sort of think through, well, does the fact that you receive services there, is that going to impair your capacity to be objective in evaluating the VA in this, or related parties in there? Do you have some sort of allegiance or fealty to the VA that makes you somewhat defensive of it, or contrary, like you're kind of, maybe you haven't gotten good services, and so you're like, yeah, you have maybe some agitation around that. And I think those would be important things for the psychologist to think through. I doubt that the VA can sort of take any sort of retribution against the psychologist for engaging as a member or beneficiary of services, but probably something to look into in terms of that. My guess is things done at a high level are not going to trickle down to the level at which an individual is receiving services, but I don't know that system, so it would be good to think about. But I think this interest of like personal experience may provide some opportunity, but may also, depending on what that opportunity is and depending on your relationship, may kind of move you in one direction or another.
Absolutely. Someone brought up in referencing back to about a person trying to escape and the organizational conflict of having an obligation to report a potential escape versus confidentiality with a client. How is this affected by, say, hearsay, where if the information about the escape is something you hear through the grapevine as opposed to directly from your client?
Yeah, that's a really good question. And I think this would be something where you need to consult the organizational code of conduct around these sort of reporting issues. I know when I worked, for example, at the Department of Corrections, they didn't care where you learned it. Right? They were like, if you heard it, whether that was in a confidential communication or you heard it, just in your sort of passing through the hall, and there was some sort of risk to the institution or person, we were supposed to report. And so I would think about, if it's something where you have like an obviously um, acutely psychotic person who is saying lots of things that are not true. And one of them is that, this other person in custody, along with, Jesus, are planning to break out. Like, maybe you might not, you might use some judgment about whether you think that is a reportable issue or something to be of concern. But if it's somewhat credible, this was part of our discussion in our group last week of like, we're not there to investigate the issue. That's why we report it, is so that other people can investigate the issue to determine whether there's a credible threat or not. And so many institutions and reporting laws are, if you hear of this, you report it and then you let those investigative bodies do their job. And so I would consult the organizational rules, think through, that, and then, just report it and then let other people, and knowing, right? I think the issue for the psychologist may be like, if someone's getting investigated for a possible escape attempt, right, they could pull them from their housing, put them in disciplinary segregation, they stop working, right? There can be a lot of negatives that happen for the person in custody, who may have had nothing to do with it, right? So I think it's important to think through those things and consult the organizational rules before you make that report.
Somebody brought up a hypothetical that I think can be sometimes relevant, particularly in programs that require their students to engage in their own therapy or psychological services themselves. This hypothetical is if a graduate student was receiving therapy from a member of their state's psychological licensure board, what are the ethical considerations in terms of asking their therapist questions about licensure or career-related issues?
So the person in training is receiving services from somebody who's on the licensing board, and
Correct.
should they use that for sort of some professional consultation?
Mhm.
Oh,
Yes.
yeah. Well, I think that's an interesting question. I like that one. I think that would probably depend. I mean, I think it's perfectly within the trainees slash therapy recipient to ask those questions. I mean, if that's how they want to use their therapeutic hour, especially if this is something that the school or the training program has required or is strongly encouraging, and you get the opportunity of having, this maybe well-known, very knowledgeable board member to do that, I think it might be a great opportunity. Now, what is the psychologist going to do, right? How do they feel about that? But I think, many of us who have provided therapy, right? Like, you have your treatment goals and your evidence-based treatments and you're working on certain things, but, like helping somebody's career may be part of their goal. Learning more about themselves or understanding the process of becoming a licensed psychologist might be something that the person is, that's part of what they're in treatment to explore, or, related to important pieces of what they're doing. And so I think if the psychologist feels comfortable, like, yes, you're providing maybe some consultation and sort of specialized knowledge that you have as a board member psychologist. But as long as you're not, releasing details about, when things have gone wrong, as they sometimes do, that the board finds out about, right? But providing some guidance and mentorship, I think that can be an important part of a therapeutic relationship, as long as it is within the bounds of how the psychologist defines that and is comfortable with.
Yeah, certainly tricky on both ends there.
Mhm.
Someone brought up the asking for your perspective on how you handle boundary issues with a referring attorney, say, who on the one hand is, requesting your assessment services for their client, but also asks you about input about how they can maximize those assessment results for their client's defense.
Oh, yes, this is a good one. This is one that comes up for us pretty frequently. And I think it is really, you come in as an evaluator, that's your main role. And now actually maybe going to testimony. And so to what extent are you being pulled or asked to move into a consultative role? Right. And so the goal of consultation is to help the attorney with whatever they want, within reason. Is usually, like, if you're hired as a consultant, is help me understand these issues, help me prepare. And the goal is to support the attorney, not necessarily help the court make the best decision. But as an evaluator, my allegiance is to the judge, or the trier of fact. And I want them to receive the best possible information for whatever decision they're going to make. And so those two roles can conflict. And I think it is an inherent pull that not only attorneys will ask us to do, but we will do internally, because if there's another evaluation on the other side that's saying Dr. Guyton is wrong, here's why, right? My natural defensive instinct is going to be like, no, they're wrong. And let me show you how they're wrong. So I think it is a tricky management to say, well, listen, in preparing for testimony, I'm happy to outline the differences between, if I haven't done that in my report already, I'm happy to outline the differences between, Dr. Smith and myself, in this case, and how I see that. If they say, well, can you write me some questions, that I can ask Dr. Smith to elicit this, I will say no, like, that's the job of a consultant. And you can't really sort of function as an independent, objective evaluator and an advocacy-based consultant at the same time, in my view. And so, and it's too much of a risk to pull me to be part of the team, if I'm doing that. So I might say, these are some of the things that I think are important, just as I would anytime when I'm being asked to testify. Like, here's some of the things I think are most important in my report. What do you think the other side is going to be asking about, or, some of the pinch points, and things like that. And I will do that, and try to sort of highlight for this person, for the attorney, where I think those differences lie. But it's really their job to figure that out. And they can either get another psychologist to come in and do that, or some other sort of mental health professional, or they can do it themselves or work with their colleagues to do it. It's not my job.
We'll wrap up with one more question. Someone brought up the differences between concurrent dual relationships and then sequential dual relationships, and the idea, any particularly unique considerations there, if you're exploring the difference between navigating concurrent dual relationships versus sequential dual relationships.
Right. Yeah, great question. And the specialty guidelines speak to this in terms of, like, therapeutic and assessment roles, that you really wouldn't want to have concurrent therapeutic, or you recognize the complexity inherent in a concurrent therapeutic and assessment role, and that a sequential role of moving from therapist to evaluator is somewhat suspect, right? Because you've gone from a therapeutic relationship where you know this individual, they're sharing a lot of information. The goal is to help them, with whatever the treatment goals are. And now you're moving into an evaluative capacity, and you can't unknow what you already know, right? And it can be very difficult for clients who saw you as their advocate to now be clinically sort of neutral about what happens to them, right? And you can see this in sort of family law kinds of issues where someone may have provided family therapy or child therapy, and if they move into some sort of custodial evaluation role, that could be very challenging because you may find that, right, that what they want is not what's in the best interest of the child, and make recommendations against that, which could be quite harmful to the person who doesn't really understand, these different roles. And so the beauty of sequential roles is one is done, and you have, right, you knew what happened, so you maybe have a finite amount of information about what happened in that one, and then you can use that to gauge whether you should enter into the new secondary role. Whereas when they're concurrent, things are active, things are live, things can move around and suddenly open up and interact in weird ways. And so I find those to be more wild card, and a little more difficult to manage, just due to sort of the not knowing what's going to happen or how they might interact or not interact.
These are the kinds of considerations that we aren't always eager to have to navigate, but very thankful, Michelle, for you sharing your expertise and knowledge with us to help all of us when we explore these, when these inevitably do come up. Very much appreciate that. Mm-hmm. That wraps up this week's Law and Mental Health series. I thank you for attending, and we hope you have a great rest of the day.
Thanks, everybody. Bye-bye.
Take care.